Welcome to literary and jury charge practice. Let's start out with some jury charge practice. Ready? Here we go. Okay, ladies and gentlemen, that is all you're going to hear from the attorneys. So you've heard all the evidence. You've heard all the arguments. The only thing you haven't heard yet is the law that applies to this case. It's probably going to take me about 25 minutes of reading. Would you like to have a recess first? Somebody, I think, says yes, so let's take a 15-minute recess. You're admonished it is your duty not to converse among yourselves or with anyone else on any matter connected with this case, nor form or express an opinion on it until it's submitted to you. Back on the record in the case of the people of the state of California versus Sigfrido Concepcion, who is here along with his attorney Dave Sanders. David Foy is here for the people along with his investigating officer Detective Thies. You probably heard the impression one man's ceiling is another man's floor. So I have for you the good news and the bad news. The bad news is I'm going to talk a lot, and Mrs. Moss is going to have to stay up with me and write down things fervishly as I read them. The good news is that you're not going to have to do that. I'm going to give you written copies of these instructions. They will go back into the jury room. I'll give you probably at least one copy for the foreperson and a couple extras for other people just to look at it any time you want to while you are talking about the cases. Also, I intend to show you what I'm doing as I go. Personally, I believe I don't know what research and stuff like that is, but I think the best way to remember something is to listen to it, read it, and then write it. That would be the best. But it would take a long time for you to write it out. So we are just going to have to go with 2 out of the 3. I do this at a fairly brisk clip because research does show my reading it to you more slowly does not enhance comprehension and becomes boring. I'm going to talk to you in a conversational tone. These are the instructions. If you're interested in noting as we go through, they have numbers on the top. So they are broken up in probably somewhat of an orderly fashion. Members of the jury, I will now instruct you on the law that applies to this case. I will give you a copy of the instructions to use in the jury room. You must decide what the facts are. It is up to all of you and you alone to decide what happened based only on the evidence that has been presented to you in this trial. Do not let bias, sympathy, prejudice, or public opinion influence your decision. Bias includes, but is not limited to, bias for or against the witnesses, the attorneys, the defendant, or the alleged victim based on disability, gender, nationality, national origin, race or ethnicity, religion, gender, identity, sexual orientation, age, or socioeconomic status. You must follow the law as I explain it to you, even if you disagree with it. If you believe that the attorney's comments on the law conflict with my instructions, you must follow my instructions. Pay careful attention to all of these instructions and consider them together. If I repeat any instruction or idea, do not conclude that it is more important than any other instruction or idea just because I repeated it. Some words or phrases used during this trial have legal meanings that are different from their meanings in everyday use. These words and phrases will be specifically defined in these instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in these instructions are to be applied using their ordinary everyday meanings. Some of these instructions may not apply depending on your findings about the facts of the case. After you have decided what the facts are, follow the instructions that do apply to the facts as you find them. Do not use the internet in any way in connection with this case, either on your own or as a group. Do not investigate the facts or the law or do any research regarding this case, either on your own or as a group. Excuse me. All right, we will stop there for now. Now let's try some literary practice. This is called Practice with a Purpose. What are your obstacles? Motivation is simply not enough to get a person through school, though. Visualizing something is great fun, but court reporting students need to practice the skill to get to that goal. Unfortunately, some may not plan for or work to remove the obstacles that are bound to pop up. One of the consistent themes in teachers' advice to students is to find the stumbling blocks that are preventing progress. Often teachers will suggest that court reporting students and court reporters review their notes to see if there is shadowing or missing letters in words that create problems, and then once those problems are uncovered, setting a way to practice those difficult words or phrases. Students should be specific about what they want to accomplish during a practice session to make the most of their time and energy. Building speed, working on straight copy for clean outlines, drilling on numbers, briefs and phrases, contractions, etc., theory reviews, reading back steno outlines to analyze hesitation areas. All of these are essential elements in developing speed, skill, and accuracy, says Janet Noel, CRI, CPE, an instructor with the College of Court Reporting in Hobart, Indiana. Many court reporting teachers will turn to drills to help students with specific problems in their writing. I advise students to practice with structure, says Linda Bland, RMR CPE, owner of Court Reporting and Captioning at Home. If you just practice one new take after another, simply writing the easy words and dropping the rest of it, you are only writing the easy words you can already write. You must focus on what you cannot write. Building speed is all about how well you know your theory. use a practice regime that allows you to recognize what theory concepts you do not know well enough so you may focus on those areas of weakness. When you practice and fall behind, for example, hesitate, it is vital to locate the word or phrase you stumbled on and work on that fingering. When you take the time to master that fingering, and for me it sometimes was hours, that work creates lifelong skill. That's truly doing the work, says Anita Johnson, RPR, CRR, CBC, CCP, CRI, CPE, retired, the real-time and court reporter trainer who founded Anita Paul International. One of the most important things about tackling obstacles is to take it in small portions. If you have too many dragons to slay, find a lizard, says Jenny Dunn, RDR, CRR, CBC, CRI of Prince Institute Southeast, based in Montgomery, Alabama. All right, now let's practice a little bit of our closing argument. Ready? Here we go. There is an important jury instruction that statements by attorneys are not evidence. During the opening statements, the defense attorney said things regarding the defendant's day on July 8th of 2012 before he went to the casino. There is absolutely no evidence in this trial indicating that any of those statements were true. And since statements by attorneys are not evidence, you are to disregard them if there's no actual evidence presented at trial. The defendant was interviewed at the Phelan Sheriff's Station by Detective William Domner. At the time, nobody except the defendant himself, of course, knew that Linda Concepcion had been shot. The defendant later returned to the scene, was photographed, then left to Bloomington to be with George Maxey, the victim's brother, which Detective Gibaltera testified. So the defendant wasn't present at 1:15 p.m. on July 9th when another deputy coroner, Andy Avery, arrived and began a more thorough inspection of Linda's body before transporting her to the morgue. At that point, Detective Domner noticed a hole in her t-shirt, which led to the discovery of a bullet wound on her breast, and that's Exhibit 14. The next day, July 10th, the defendant rode with the victim's brother, George Maxey, to the Long Beach airport to pick up Georgina Richardson, who had flown in from Alaska. Then they drove to San Bernardino County Sheriff's Headquarters, where all three were interviewed. Detective Gibaltera directed deputies not to release information about how the victim had died. In Detective Domner's interview, the defendant, he did not tell him. At some point in the day, the defendant encountered Lee Guerra, who was then secretary for the sheriff. Ms. Guerra has dealt with him in the past on unrelated matters, and Ms. Guerra asked how his wife was. The defendant said, quote, his wife had been shot, then quickly corrected to say that she died. This was testified to by both Georgina and George Maxey, although Mr. Maxey remembered only that the defendant said she had been shot. Obviously, since the cause of death was being kept a secret, the only way the defendant could have known she was shot to death is if he did it. Now, it is true that George Maxey said about 3 days after July 10th, which would have put it at the time of the second search on July 13th, a sheriff's deputy slipped up and disclosed Linda had been shot, but that still doesn't explain how the defendant would have known it 3 days earlier on July 10th. Yes, it's true, we called as a witness Lee Guerra, who said she didn't remember the defendant saying she had been shot. But why wouldn't she remember? Well, remember, Ms. Guerra is not close to the defendant or Linda. It's not like they are friends. They never socialized. She would have no particular reason to realize that this was important. Right, let's get back now to some literary practice. On practicing with a purpose. Ready? Here we go. Building speed is like eating an elephant. Just take one bite at a time, says Kruger. It is a very big, very daunting task to go from never writing a single word on a steno machine to achieving a writing speed of 225 words per minute. Just take it step by step, taking one bite, chewing, learning it well, and then moving on to the next. You will attain your goal of becoming a court reporter if you take it one bite at a time. Another bit of advice is to practice numbers and finger spelling to improve output. Typically, the first 15 to 20 minutes with witnesses and expert witnesses for all freelance and judicial reporters is numbers, says Monet Benoit, CRI, CPE, a court reporting tutor and career coach based in New Braunfels, Texas. When students and reporters master their numbers, the first few minutes of a deposition are a breeze. Sometimes students will tell teachers that the testing makes them nervous and on edge. Getting around testing anxiety can be problematic even after students graduate, but employing some strategies to deal with testing anxiety as an obstacle can help bring it down to size. I tell students that if they treat each practice session as though it were a test, testing will seem normal to them. In practice sessions, they gain the knowledge of identifying problem areas that need addressing, inclusive of misstrokes as well as English and punctuation. This means warm-up, practice, transcribe, self-grade, the same steps as testing, says Janelle C. Adams, RMR, CRR, CRI, a teacher at Hines Community College in Jackson, Mississippi. Desensitizing nerves about testing is important, and developing a mindset that every word you write is as important to you as it will be on test day can help get you there, says Deborah Dubuck, RPR, CRICPE, a teacher at AIB College of Business in Des Moines, Iowa. All right, and that will conclude our literary and jury charge practice.